Now I am going to dictate a legal passage based on Kolkata High Court judgments on land issues and partition at the rate of 120 words per minute. Let's start. Application for preemption under Section 8 of the LR Act would be maintainable in respect of a land in the nature of Vastu. Stop para. In the case of Srimati Atarjan Bibi and others versus Sheikh Ashak and another, reported in 4 CWN 788, the plaintiff and the defendant were the co-sharers in a Putni Taluk. Stop. They had equal interest. Stop. The plaintiff in that case alleged that the defendant had dug a tank in the joint property, in spite of protest, and he wanted a decree for restoration of the land to its original position. Stop. This court held that by digging the tank, no injury was caused to the property. Stop. Therefore, the plaintiff could not have the tank filled up or the land restored to its former position. Stop. But he was entitled to a declaration of title in the tank to the extent of his share. Stop. Para. It is settled law, the property once vested cannot be divested without due operation of law. Since the property in question has been vested lawfully in the state, there cannot be any question of the requisition under Section 6 of the West Bengal Act II of 1948 in view of end of Act II of 1948 and amendment within bracket state of Act I of 1894 as claimed by the petitioner. Stop. Para. Having regard to the fact that when one of the admitted co-sharers transferred a portion of his share in the suit property, the purchaser automatically became co-sharer by virtue of purchase. As such, in the absence of those co-sharers, the suit for partition cannot be held to be maintainable. Stop. Para. It is true that there may not have been partition of the larger plot in accordance with Section 14 of the 1955 Act, but partition and demarcation are not the same thing. Stop. There may well be physical demarcation of a plot of land, carving out smaller demarcated plots with separate identities without there being partition in accordance with Section 14 of the 1955 Act. Stop. Section 2 within bracket 6 talks of undemarcated interest and not of unpartitioned interest. Stop. In my view, the petitioner cannot be said to have an undemarcated interest in the suit plot or for that matter, any interest in the suit plot. Stop. The petitioner's interest is limited to the Schedule A and Schedule B properties. Hence, in my opinion, the petitioner cannot be said to be a co-sharer in respect of the suit plot. Stop. Para. The date of registration of the document transfer is the date when the document comes to the public domain and a person is deemed to have knowledge of the document from such date. Stop. Thus, a non-notified co-sharer is entitled to petition for preemption under Section 8 of the Act of 1955 within a period of 3 years from the date of registration of the impugned document of sale. Stop. Para. There is no two opinion on the position of law that if statute prohibits partition of a particular class of property except by way of registered document, then unless partition is effected by a registered deed, there can be no partition in accordance with law even if the parties actually made oral partition. In such a case, if the co-sharers remain in occupation of a particular demarcated portion by such mutual arrangement, for such arrangement their undemarcated interest in the plot is not extinguished. Stop. In the eye of law, they remain co-sharer so long there is no registered deed of partition, notwithstanding the fact that each of the co-sharers are in occupation of a particular demarcated portion. Stop. Para. Under Mohammedan law, if the donor and donee are residing in the same property, it is not essential that the donor should depart from the premises to deliver possession to the donee. Stop. Thank you.